Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. Welcome back to the Listen and Learn series. Today we're discussing torts, and specifically proving the breach element of a negligence claim. Remember, to prove a negligence claim, the plaintiff must establish 4 elements: duty breach, causation, and damages. Today we will discuss what exactly a plaintiff must prove to establish the second element with some methods that a plaintiff may use to do so. We will also talk about a doctrine that a plaintiff may use if the plaintiff can show that their injury normally does not happen unless someone breached a standard of care, but the plaintiff does not know the specific way in which the defendant breached their duty. And we will walk through some hypos to illustrate different methods of proving breach. But before we jump in, let's take a few minutes to clarify a vocabulary issue that comes up in negligence case law with regard to this second element. Courts use the word negligence to refer to 2 things. First, they use it, as we have so far in this podcast, to refer to a negligence claim. For example, if a court says plaintiff has sued defendant for negligence, the plaintiff must prove all 4 elements of a negligence claim to be entitled to damages. Alternatively, courts sometimes use the word negligence or negligent when discussing the second element of the plaintiff's claim, a breach of the standard of care. For example, a court might say, plaintiff has established that the defendant was negligent by failing to double-check the safety harness. And plaintiff has also proved the defendant's negligence is the actual and proximate cause of plaintiff's damages. In this case, the court is using the word negligent to refer to the second element of a negligence claim, breach of the standard of care. In other words, a plaintiff is not necessarily entitled to the damages just because a defendant acted negligently, meaning the defendant breached the standard of care. To be entitled to damages for their negligence claim, the plaintiff must also prove that the defendant's negligence or breach of that standard of care actually and proximately caused the plaintiff's damages. If this semantics issue is causing extra confusion, do not worry too much about it. In context, it is usually easy to determine whether a court is using the term negligence to refer to the plaintiff's entire claim versus when the court is using the term to refer to the second element, breach of the standard of care. Just be aware that if you feel like courts are using negligence to refer to the 4 elements as a claim as well as the second element only, you are probably right. Now that we have discussed how courts sometimes refer to this second element, breach of the standard of care, as someone acting negligently, let's talk about what a plaintiff must show to prove this element. Here you will likely notice that this second element, breach of a duty of care, is related to the first element, the duty that the defendant owes the plaintiff. In other words, whether a defendant breached a duty of care depends on what standard of care applies and what that standard requires. In most cases, the reasonable, prudent person standard applies. This is the standard on which we will focus during our discussion today. Just remember that there are circumstances in which this reasonable person standard of care is replaced by a more specific standard of care, such as the duties owned by landowners, professionals, and children. We focus on those standards in other podcast episodes, and you can find a link to those episodes in the show notes below. But for today, let's get back to the reasonable, prudent person standard of care. Under that standard, every person owes a duty to all foreseeable plaintiffs to act as a reasonable, prudent person would under like circumstances. Stated another way, every person owes a duty to conform their conduct to the standard necessary to avoid an unreasonable risk of harm to others. To determine whether a defendant has breached this duty, we must know what a reasonable, prudent person would do under the circumstances. Here are some general guidelines about this reasonable person. First, the reasonable person is only required to consider the foreseeable risks of injury that their conduct will impose on the community. They are not expected to consider risks that are unforeseeable. Second, the reasonable person is not required to completely avoid all foreseeable risks of injury. Rather, we accept that everyone must do things on a daily basis that pose some risk of injury to others. For example, if you have driven a car, played a sport, or mowed your lawn, you have engaged in an activity that poses foreseeable risks of injury to others. And you are not expected to completely avoid all of these risks, especially when the only way to avoid all risks is to not engage in an activity that is essential to daily life, such as driving a car. Instead, you are expected to consider the risks of injury in light of the utility of your conduct. So, in the case of driving your car, you must take precautions to avoid foreseeable risk of injury to others while driving your car, in light of the utility of being able to drive a vehicle. To determine what precautions are reasonable under the circumstances, the reasonable person must consider both the extent and the likelihood of the risks. In the case of driving a vehicle, there is a serious risk posed to others on the road. Every year, tens of thousands of people die in auto accidents in the United States. This means that the extent of the risk posed by driving your car is catastrophic. That being said, the likelihood of catastrophic injury from driving is fairly low, considering that there are over 250 million drivers in the United States, and these drivers drive an average of nearly 30 miles per day. In other words, the number of people who suffer catastrophic injuries while driving a vehicle is a small percentage of the millions of drivers on the roads. So while the extent of injury from driving is high, the likelihood of catastrophic injury is low. Additionally, there are simple precautions that drivers can take to avoid the risk of catastrophic harm to others, such as obeying traffic laws. For example, a reasonable person would not drive a car at a high speed on the interstate while texting, because in most circumstances, the burden of not immediately replying to a text message is far less than the extent and likelihood of an injury posed by looking at your phone rather than the road. This brings us to the first tool that a plaintiff may use to show that someone's conduct fell below the reasonable person standard, the BPL formula. Under this formula, if the burden of taking a precaution is less than the probability times the extent of the injuries, a reasonable person would take the precaution. In other words, when the burden of taking a precaution is low and the extent times the likelihood of the injury is high, a person who does not take the precaution has likely breached their duty of care or acted negligently. So let's use a hypo to illustrate how the plaintiff and defendant may use the BPL formula to argue that the breach element is or is not established. This hypo is adapted from a question on the July 2021 California bar exam. Hospital, a private hospital in California, maintains a policy that food served in the hospital must never be left unattended before, during, or after meal service to prevent contamination or tampering. Hospital's kitchen staff are trained on the policy and required to stagger breaks so that at least one member of the staff is always present in the cafeteria to monitor accessible food. Hospital also has a security guard responsible for patrolling the cafeteria. Recently, Denise Davis, the chief executive officer of Hospital, received a series of anonymous email messages threatening to carry out a massive attack at the hospital. In response to these threats, Davis decided to reassign the security guard from patrolling the kitchen area to patrolling the hospital lobby and the entrance area. Davis did not share the information concerning these threats with anyone else at the hospital. Several days later, Frank, a former patient, entered the hospital kitchen shortly before lunchtime and mixed peanut powder into a serving tray full of mashed potatoes. No kitchen staff was monitoring the potatoes at the time they were contaminated because they had all left to use the restroom. Patrick, a patient, consumed the mashed potatoes. Patrick, who has a serious allergy to peanuts, suffered severe injuries. Patrick sued Hospital and Davis for negligence. Regarding Davis, Patrick claimed that Davis breached her duty of care to Patrick by reassigning the security guard from the kitchen to the lobby and entrance area. How can Davis use the BPL formula to argue that she did not breach her duty of care? And how should Patrick respond? So let's talk about Davis's arguments first. Here, Davis will likely argue that the burden of maintaining an extra security guard in the cafeteria outweighed the extent and likelihood of injury. Even though food contamination could cause severe injuries, as it did in this case, the likelihood of severe injuries is small for two reasons. One, the most common injury from food contamination is food poisoning, which is not nearly as severe as a reaction to a serious allergy. And two, the likelihood of any contamination without the security guard in the cafeteria was small, because the policy required a member of the kitchen staff to be present to monitor the food at all times. If the kitchen staff had complied with their job requirements, it is unlikely that Frank's tampering with the mashed potatoes would have gone unnoticed. And the chances of all kitchen staff going to the restroom at the same time is an unusual and unexpected occurrence. Moreover, the burden of not moving a security guard to a location with a far more immediate threat is high, unless hospital could afford to have an extra security guard on staff for the duration of the threat. Hospital had to move a guard from somewhere to have extra support to protect against attack. This may have required moving a security guard who was in a higher risk area than the cafeteria, or just keeping all guards in place and being vulnerable to an attack. Given these facts, Davis will argue that she acted reasonably by reassigning the cafeteria security guard to account for the greater threat, given that the risk of any unnoticed contamination in the cafeteria was low. On the other hand, Patrick will likely argue that the hospital's policy indicates that the hospital knew food contamination was a potential problem, indicating that there may be a high likelihood of this happening if the food is not monitored. And Patrick will argue that the extent of injury from food contamination can often be severe. Even food poisoning can be life-threatening, particularly to hospital patients who are already severely ill. Furthermore, Patrick will note that there are alternatives to removing the security guard from the cafeteria that Davis should have considered, such as having an extra security guard in the lobby and entrance following the threat without reassigning any of the other guards. In other words, hospital could have just paid to have one more guard on duty during this time. Although this is some burden to hospital, if Davis had told the board or others about the threat, it may not have been difficult to get them to agree to have extra security on the premises. Or Davis could have reported the threats to the police, who may have been willing to assist with additional security. This brings us to some of the additional things that a court may consider regarding whether the defendant breached their duty of care. For example, were there, as Patrick would argue here, alternatives that Davis should have considered before removing the security guard from the cafeteria? The court may consider industry custom. Do most hospitals always maintain a security guard in the cafeteria, regardless of whether there is a threat requiring extra security in another part of the hospital? Regardless of the answer, this industry custom is merely evidence of what a reasonable hospital CEO would do. It is not determinative. Another potential consideration is compliance with a statute or regulation. As you likely know, failure to comply with a statute may establish the duty and breach elements of a negligence claim if the elements of negligence per se are satisfied. For a more in-depth discussion of negligence per se, see our Listen and Learn episode on this topic, linked to in the show notes. However, compliance with a statute or regulation does not insulate a defendant from a finding of negligence. So let's look at another hypo to illustrate how a defendant may be found negligent despite compliance with a statute. Patty is driving on the interstate in pouring down rain. She's going 45 miles per hour, which is well under the speed limit of 60 miles per hour. Patty hydroplanes and hits David's vehicle, sending him into the cement wall interstate divider. David is severely injured and sues Patty for negligence. At trial, Patty argues that she did not breach the standard of care because she was driving well under the speed limit. However, David argues that given the pouring rain, a reasonable person would have been driving at an even slower speed than Patty. Here, Patty's compliance with the speed limit does not insulate her from liability. And depending on the circumstances, David may have a strong argument that a reasonable person would have been driving at an even slower speed than Patty given the pouring rain. As these hypos illustrate, whether a defendant breached the duty of care is often a very fact-intensive analysis based on the circumstances of that case. Whether Patty was negligent by driving 45 miles per hour instead of an even slower speed will likely depend on testimony about the extent of the downpour and what other cars on the road were doing. For example, if most of the cars had initiated their emergency lights and slowed down to 15 to 20 miles per hour, That is strong evidence that Patty was not acting reasonably by driving 45 miles per hour. On the other hand, if Patty was moving with the flow of traffic and using her emergency lights, that supports a finding that Patty was acting reasonable under the circumstances. Now that we have covered some hypos regarding how a plaintiff may show that a defendant's conduct fell below the applicable standard of care, let's talk about a doctrine that allows a plaintiff to prove breach even if the plaintiff does not know the specific conduct that allegedly breached the standard of care. This is the doctrine called res ipsa loquitur. A plaintiff is likely to use res ipsa loquitur when the breach element of their negligence claim is very difficult to prove. To use res ipsa loquitur to prove breach, a plaintiff must show 1. That the injury is of a sort that typically does not occur in the absence of negligence, 2. The instrumentality, the thing or object, which caused her injury was in the defendant's exclusive control, and 3. That the plaintiff did not cause or contribute to the injury. So let's look at a hypo to illustrate how this doctrine works in practice. Paula is known for her excellent cooking skills and attention to detail in the kitchen. She often throws lavish dinner parties for her friends and makes everything herself from scratch. Paula's friends have offered to help her prepare the meals for these parties, but she always refuses. As her friends suspect, Paula is extremely meticulous about food safety, and it makes her too nervous to have anyone else in the kitchen when she is cooking. What if they did something wrong and someone got sick? Paula would never forgive herself for letting someone else interfere with food. This weekend, Paula is hosting a 5-course dinner party for her friend's birthday and plans to serve homemade pasta with tomato sauce as a second course. She is using her grandmother's recipe for the pasta, which only uses 4 ingredients: flour, water, olive oil, and salt. Before Paula starts mixing any ingredients, she ensures that her workplace bowls, spatulas, and measuring cups are perfectly clean. Then she starts combining her water and flour to form a light dough. She adds a splash of olive oil and a pinch of salt. Now she is ready to roll out and cut her pasta. After Paula double-checks that she has a clean board, rolling pin, pasta cutter, and pasta hangers. Paula rolls out the dough and cuts it into thin strands of spaghetti. Then she hangs it over the pasta hangers to dry. Once the pasta dries, Paula will package it in clean plastic bags to boil for the meal. For the sauce, Paula is using mostly homemade crushed tomatoes from her garden, olive oil, salt, and a pinch of sugar. Paula puts these ingredients in a clean, large pot and brings it to a simmer. Then she adds the only store-bought product she plans to use for the meal, 1 jar of Raoul's store-bought pasta sauce. Shortly before the second course is served, Paula personally boils the pasta in a clean pot and heats the sauce. She prepares and serves each dish and is positive that no one had access to tamper with anyone's dish before it is served. Unfortunately, during dinner, one of Paula's friends bites into her pasta and breaks her tooth on a hard object in the sauce. After examining the object, they determined that there was a rock in the pasta sauce. Paula's friend sues Raoul's for negligence. Can the friend use res ipsa loquitur to establish her claim? Possibly. It seems very likely that a rock would not have ended up in Paula's sauce unless someone was negligent. The problem in this case, of course, is to decide whose negligence it was. Was it Paula's or Raoul's? So Paula's friend would likely rely on Paula's testimony about the care she took in the kitchen at each step to eliminate Paula as a potential source of rock in the pasta sauce. In res ipsa loquitur cases, it is quite common for plaintiffs to offer testimony to eliminate the negligence of others, so as to satisfy the requirement that the negligence be attributable to the defendant, given the evidence of Paula's care in each step of her preparation. Paula's friend may have enough evidence to let a jury decide whether Raoul's was negligent based on res ipsa loquitur. And with that, we have ended our discussion on the breach element of negligence claims. Thank you so much for watching. If you enjoyed this episode, please give us a like, leave a comment, and subscribe so you don't miss any future episodes.